2, Mr. Davenport is a bond hearing. And is that you also, Ms. Wood?
Yes, Judge, I'll be handling that today.
Okay. Ms. Feely starts tomorrow?
Yes.
Is she already here and being programmed, or tomorrow starts her programming?
I think tomorrow starts the program.
Okay. And you haven't heard anything that suggests she won't show up tomorrow?
I'm keeping my fingers crossed, Judge.
Have you met her before?
I have not. I've
Okay.
heard great things though.
Okay. So you'll meet her maybe tomorrow.
Yes.
All right. Position 3 is Delon Loomis. And that's a status calendar. Is this our first status conference since we started doing that?
Yes. I do.
It's gonna be exciting. We'll bring him out at the appropriate time, and it's just a way to make sure everything is copacetic, because Mr. Loomis will next appear on a trial calendar, and not something in between because, oh, I don't have body cam or something like that. So we'll talk about that. Position 4, Justin Jones is here. Hey, all right. Your case, Ms. Wood?
Judge, this gentleman was on the April 25th calendar. There's an address in Odyssey that says that he changed it to Philadelphia. I received a phone call last week from my director, a voicemail, where Mr. Jones was informing us that he didn't change the address, so that's why he missed court. I do need to get that updated for him. And then I do want to speak to him, just to make sure he qualifies.
Okay, if he qualifies, you can help him out today. At a minimum, maybe we can work through this warrant.
Yes.
Okay, and when you say your director, what does that mean?
Mr. Kenneth.
Oh, all right. Does he usually call you about cases? Panic time. All right, Mr. Jones, you can take a seat. Please don't go anywhere till Ms. Wood has a chance to talk to you, okay? Position 5, Mr. Fox is back. Are we working out Mr. Fox's cases?
Yes, Judge, this, Ms. Hall is in Judge Whitaker's courtroom. She asked me to let you know that.
Okay,
Mr. Fox is actually with Judge Gorski. I just came from down there making that announcement. So,
Okay.
he should be brought up at some point.
all right. I would say as soon as we can get everyone, he should jump to the front of the line if he is in a happy space. So you can confirm that he's in a happy space. If he is, then let's take care of that once we get Ms. Hall. We won't interrupt a plea we're in the middle of, but we will handle Mr. Fox as soon as he's here and Ms. Hall is here.
Yes.
All right. Position 6, Vondi Humphrey.
Judge, the next 3 physicians are not going to be here, if I can go ahead and tell you that. These were added sort of as a fingers crossed. Ms. Charles and I had spoken Friday afternoon. Mr. Humphrey is residentially challenged, and
Okay.
his aunt was unable to locate him
Okay.
for today. So I would ask that no bench warrant be issued.
Okay. Because the notice was effectively you saying, I'll do my best to get him here.
Yes, Judge.
Okay. All right. Ms. Charles, any objection to handling it that way? Let's, if and when Mr. Humphrey makes contact with you again through his relative or whatnot, let's try to grab him, get a date. It in theory doesn't even need to be a published calendar as long as Ms. Charles is available and you can get Mr. Humphrey in here. Looking at the charges, I see why everyone was ready to work this one out. And maybe we get Mr. Humphrey plugged in with some resources. Okay. How about Harvey Johnson?
This same announcement, this is one of Ms. Patel's clients that I was hoping we could resolve. He's also got some challenges with stable housing, so I was not able to find a good number for him at this time.
Where are, so are these going to pop up on a trial calendar next? Is that really the next stop? Yeah, I'm going to just look one of them up. I'm fine handling this the same way. I was going to shower praise on the 2 of you for, hey, here's a day, we could bring some people in. So I'm not unshowering. I appreciate the effort you 2 made. And we're learning one reason why it's tricky sometimes on short notice to get folks in here because they're hard to track down if they don't have a stable address. But I want to make sure that the cases continue to move forward. So, okay, they're going to be on a trial calendar. They'll get notice, whatever notice might mean for them. So hopefully they do resurface, Ms. Wood, and you or Ms. Feeney.
I think it's Feely with an L.
Feely can get him in here. Presumably the state's offer would be about the same because the state hasn't had to do anything more between now and then. Yeah, they're looking for a late summer trial date. And then Marcus Blanding.
Same announcement, Judge, although I have spoken to him as recently as early last month. He was actually in my office. I'm confident we can resolve this one short of trial. It was just a matter of not being able to reach him before.
Okay. So 6, 7, and 8, we will basically they'll move to a trial calendar, but anytime you track any of them down, just reach out to Ms. Nelson and we'll figure out where we could tuck any one of those in. Lunchtime during a trial, take a plea or something like that.
Thank you, Judge.
You bet. Well, it's gonna make our morning shorter. So we can't do Sargosa Garcia yet. We don't have a lawyer for the state to handle Davenport unless you were going to do that, Ms. Charles. So we could bring Mr. Loomis out. Is there anyone in court who's got a case they didn't hear that case called? Or you're all here for one of the names you heard?
We're here for Davenport.
Okay, that is a vocal group. All right, well, we will have the bond hearing for Mr. Davenport once the prosecutor, that case gets here. But we're doing outreach now. So why don't we bring Mr. Loomis out, please? Okay. Just give me 1 second, sir. I'm getting your case up here. All right, let's go on the record with the status conference. State versus Delon. Is it pronounced Loomis? Mr. Loomis, your case is 21 SC 178823. You're charged with armed robbery and a few other felonies. And we are going to talk this morning about where your case is, what the state's offer is, because next up, if everything is squared away, is to get you a trial date. You are sitting in jail and we need to get your case resolved, whether that means a plea or a trial. The jury will decide what ought to happen, but you're certainly entitled to that. Ms. Charles, is it your belief that discovery is complete in this case?
It is, Your Honor. However, this was explained to me she was having some issues with the body camera. So we both brought our laptops. She's going to show me what issues she was having, and I was going to walk her through what I had and what I see. I was able to get her to play, so she's having some difficulty in play on her end.
Okay, so you can play all the files on your machine. There may be a codec or whatever the right term would be issue for Ms. Wood. Okay, but you're not aware of anything that Ms. Wood has flagged for you of, hey, there should be this report or this that you haven't been able to track down. Okay. Ms. Wood, what's your report on discovery?
Yes, Judge. So Ms. Charles did send me an email letting me know that she had shared it with me on evidence.com. I'm looking for about 12 photos and 15 videos. The issue is that when I log in, it doesn't show that she shared it, but we're going to compare notes after this because I'm wondering if you recall, I've had some issues getting my name change worked out.
Yeah.
And so I do know that there was a time when someone would share it to Kyle's, and then when I log in under Wood, it doesn't.
It's not there.
Over.
Right. Two different people.
Yes, and then also evidence.com, when we first started using them, we didn't have a public defender platform and now we do. And so I'm not sure that might be part of the issue, the technology. So we will get together after this and make sure I've got everything.
Are the photos and the body cam real time in the sense this is the crime occurring, or they are interactions with law enforcement and alleged victims, and then maybe that same day or 5 days later, interactions with law enforcement and your client? And you may not know because you haven't watched them, but one of the two of you hopefully can answer that.
She'll probably be able to answer better because I haven't seen it, but I do expect, I believe the police report mentions that the camera is what led them to identify a suspect. So that is especially what I'm looking for, but I'm not sure if you've seen it.
The report that, as I stated, there is video from the MARTA platform that captures some before and some prior.
Okay, so it's not necessarily body cam. There may be body cam video, but now that you've said MARTA, it's cameras. I mean, that's a camera on the person, but it could be cameras attached to MARTA property. Got it. Okay. It doesn't sound, Ms. Wood, like any of that would result in a motion to suppress because it is, we'll call it surveillance video. And so anything said on it wouldn't be the result of an interrogation or anything like that. I don't see any motions pending that would require a hearing. Is that accurate?
That's accurate.
Okay, great. Ms. Charles, what is the state's recommendation at this point if Mr. Loomis wanted to work his case out?
It will be 26.
Okay. And how long is that offer something that would stay open?
Until trial.
Okay, all right. So Mr. Loomis, it sounds like until the state needs to start getting ready for trial, the state's recommendation in your case would be, it's the mandatory minimum for armed robbery that carries a 10-year mandatory minimum. I assume it would be 10 years probation following the 10 years in custody. Do you understand what the state's recommendation is? You need to answer out loud.
Yes.
Okay. I just need to make sure it's on the record so that when you and Ms. Wood are talking about what ought to happen with your case, you are talking from the same perspective, that if you wanted to enter a guilty plea, the state would recommend the minimum. Really, Ms. Wood's not in a position to ask for less unless the state wants to invoke a obscure statute that allows me to go below the 10. But you do know they're not asking for more than 10. Armed robbery can be up to life, so it's a big range in there. All right, Ms. Wood, it sounds like you'll get a chance to look at the video and we may be able to work through the technological issues because, of course, you're going to want to share it with Mr. Loomis. If, in fact, there's footage that the state or law enforcement contends, hey, that's your guy doing X or Y or Z, you'll want to digest that, and so will Mr. Loomis before he decides how he wants to move forward. Anything else we need to cover before we wrap up for today?
I think that's all, Judge.
Okay, well, Mr. Loomis, the next time I see you, it will either be because you've decided to work your case out short of trial, or because we're calling that trial calendar and it's your turn for the trial. There are cases ahead of yours. You've been in jail for a long time. Sadly, there are people who've been in jail even longer, and we try to work our way from oldest to least old. But sometimes there's a reason why we can't reach an older case. And I'll be looking to move yours when we can on a trial calendar. And that calendar looks like for now it would be in July. So not too far from now. Plenty of time for you and Ms. Wood to do more prep work for you to see these videos and to see if you're going to work the case out. And if not, then we'll get it on the trial calendar. Any questions?
Your Honor.
Okay, so Ms. Wood will be checking in with you once she can get those videos and still pictures to work for her. And I'll next see this on a trial calendar unless you all reach out to Ms. Nelson. Ms. Charles, anything else in Mr. Loomis's case? All right, Ms. Wood?
No, Your Honor.
All right, thank you. Not a problem. We've learned not to rely on that guy ever since he cut and ran from this courtroom. And we had other stuff to work through. So Ms. Charles and Ms. Wood, that was maybe a little bumpy version of what we'll be doing more routinely now. We won't be having final plea calendars, but this is kind of final plea, but it's also a chance for people to flag discovery issues so we can avoid, it's trial calendar and I don't have my client's confession, or I've never heard that offer. Now it's on the record what the offer is. So when you see status conference next to a case, these are the things we'll cover, plus anything else you all might want to bring up. And we really shouldn't be scheduling status conferences if you filed a motion that requires a hearing and we haven't had that hearing yet. The point of the status conference would be, all right, I've ruled a motion to suppress. The drugs are not coming in. Well, that might change the offer. They are coming in. That may change the desire to plead, so that when we have that conversation, it's really, other than this kind of technical issue, which seems very solvable, we're pretty much ready for trial. It may not be a trial, but we're ready for trial. We're also going to have smaller trial calendars, which is why these are important, because if we don't have a behemoth 50 position trial calendar and 6 of the cases, the defense attorney says, well, I never got discovery, we're not going to have a lot left on that calendar. So we'll be doing more of these status conferences. We'll usually have the client involved. They may be Zoom based, but it often helps because it may be that the defendant hasn't connected with the judge since plea and arraignment. And there's also a little bit of a breakdown in terms of defense attorneys being able to be persuasive with their client about, hey, here's the judge and here's what he's like, if there was a waiver of arraignment and then there's a trial calendar. So these will take a few minutes. They won't take as long as this one as we get the hang of it, but that's what we'll do. Okay. All right. Mr. Theory, how are you?
Fine, John. How you by yourself?
I'm doing all right. I don't know that you've got a case on here, but it's always good to see you. What brings you here today?
I was waiting to see if Mr. Roberson was brought over. He wasn't on this calendar.
I was hoping Mr. Roberson might come today as well, since we took the plea in Mr. Roberson's co-defendant's case, but we didn't hear back from anyone. If that had been sorted out, is that something that has been sorted out, or where are we with that?
I originally received the offer from Mr. Abadi, and I related to my client, and it was something they was inclined to take.
Okay.
We had a late conversation late afternoon yesterday, and so at this point, I was thinking Mr. Abadi may have actually be brought over today.
He didn't. It would typically come from the defense attorney rather than the prosecutor. So going forward, if you're thinking there's a possibility, reach out to Ms. Nelson, and then she'll let you know, not in time, or we can squeeze this person on the bus. I don't think we'll probably be able to get them over here today. We can see if there's a second bus, but if there's not, what we may try to do, consistent with your schedule and Mr. Abate's, is to see if we could borrow one slot on someone else's jail calendar later this week to get Mr. Roberson here. It would be great to resolve that while it's fresh for everyone. It's pretty fresh for me, having taken Ms. Marable's plea. I now much better understand the strange dynamic of the case, why the state has made the offer it has, and probably why Mr. Roberson would want to resolve it, given what happened with Ms. Marable. So I'll have Ms. Nelson check to see if there's any way to get Mr. Roberson here later today. If the answer is no, then are you feeling pretty confident, Mr. Theory, that bringing Mr. Roberson over makes sense? Because he's not just inclined, but he told you, yeah, let's sort this out this way.
Yes, Your Honor.
Okay.
I'll be ready if Mr. Abadi's, I know you're in different courtrooms.
Like you.
Another day.
And so let's figure out what we can do. It'd be great to take care of it this week.
When you get him over here, I'll make sure no matter what.
Okay, so we got Mr. Abate who's bouncing around in this building. You sometimes are remote, sometimes you're here, although you told me it doesn't take you so long to get here.
Yes, I can be here, Your Honor.
Okay, so why don't we figure out a time this week, if possible, that we can bring Mr. Roberson here, and it's looking like Friday may be the day that we can do that, but we won't surprise you with that. We'll confirm it. We've got a calendar in the afternoon, a plea and arraignment calendar. And so we might tack it on to that.
Friday will be fine for me.
So no trips to Louisiana mid-Friday. You have to go Friday evening.
No, sir.
Okay. We'll send out a confirmatory email to both you and Mr. Abadi, so there's no guesswork, but assume it would be Friday, and hopefully, I don't know how you were able to connect. I know the phones aren't always working so great out there, but if you could just let Mr. Roberson know, that's the plan.
Yes, sir.
Next week, we're supposed to be picking a jury. We were going to pick a jury in the Lowe case, not yours. And much to everyone's chagrin, we learned that the public defender's office may have a conflict 13 years later on that case. So the backup was, I think, a case of yours. What's the name? Reynolds. Michael Reynolds. I think he's on bond. Yeah, was that one, the look you're giving me, even though most of your face is covered by the mask, says probably you're not ready on Reynolds.
Your Honor, I had a specially set case in front of Judge Cox that was reset from the 16th to the 23rd. And so then I had a specially set case with Judge Adams that I prepared for the 31st. So perhaps I could be ready for Mr. Reynolds on the July calendar.
But not for Monday.
No, sir.
Okay. Does specially setting things help you prioritize?
Yes, Your Honor.
Hence the Adams special setting and the Cox special setting.
Yes, sir.
How many different courtrooms do you occupy at this time?
9, Your Honor.
9. Is it the case that some judges have a conflict defender that they share with only one other judge?
I deal with the 7 deadlies period for those 9 courtrooms.
I understand, but we've got 15 judges who have criminal cases. So you're not across all 15. You have 9. So that means there's 6 other judges who've got 7 deadlies, and you don't cover those. Do those 6 judges share one conflict offender across all 6? Or is it like in the good old days, there are actually 3 conflict offenders across those 6 courtrooms?
I think there are 2 or 3 conflict offenders handling cases in those courtrooms.
That's an interesting allocation of resources. Okay. So no to Reynolds on the 16th. We'll let Ms. McCauley know. She's the prosecutor on the case. And we'll see what we can do on the 16th. And we may specially set cases for you, but we'll talk offline. It'd be better to specially set ones you are more ready for, like Tolbert, or I don't know where you are with some of those, but we'll talk offline. But plan on Friday being here for Roberson.
Yes, sir.
All right. Thank you. All right. Shall we do the bond hearing in Davenport now?
Yes, sir.
Please, Judge.
So, Ms. Jackson, we are going to have one plea once we get the interpreter here. The other pleas we had to move because folks didn't show up, but we will do that.
Okay, thank you, Your Honor.
Does Miss Love know about the conflict?
She was on the call last night.
She is ferociously still working on the case.
She was encouraged to come up with a non-trial resolution. But it's tricky. The conflict is with a 404B victim. Ms. Primovic, in fact, represented the 404B victim 10 years ago. She didn't remember that. And they were running the info when the witness list came through. And so poor Ms. Love needs to decide, get a conflict defender and try the case in 6 years. Or don't use the 404B, and it's good 404B. But I know she's trying to get ready. But then there's that third scenario of, hey, you need to sit down and not do that, okay? Mr. Davenport, I'm just getting the bond motion up. Hey, Mr. Davenport, you need to be looking this way, or we'll need to get folks out of the courtroom if they're going to be a distraction for you.
I apologize.
No, it's all good. This is an emotional moment. I'm not happy with anyone about that. We just need to make sure we handle this in an orderly way. All right. This is position 2 on the status calendar, State versus Marion Davenport. It is 21 SC 179557. And in March, Ms. Patel, who was with the Public Defender's Office and represented Mr. Davenport, filed a petition for bond. As I mentioned, Ms. Patel was with the office. Ms. Wood was Ms. Patel's partner and is handling this bond motion for Mr. Davenport. We've got Mr. Abate here from the state. And Mr. Davenport, all we're going to do today is talk about bond. So I'm going to hear from Ms. Wood why it's a good idea to give you a bond and what that bond should look like. And then I will hear from Mr. Abate to see if he disagrees, and I bet he does, with the idea of bond. And he will tell me the reasons why he doesn't think you should get a bond. There may be people that Ms. Wood wants me to hear from on your behalf. There may be people from the deceased's family that Mr. Abate wants me to hear from. They have a right to be heard in this setting as well. And then I'll let you know what I'm going to do, and we'll keep moving along. Where are we, if you know, Ms. Wood, in terms of ensuring that you've got the discovery in this case?
I'm happy to confirm with Mr. Abadi. I did go through the file. There's a substantial amount. There's 2 CDs, 2 USB drives. So I know it's a lot. I'm not sure if it's everything, but it's substantial, Judge.
It's not a thin folder.
Correct.
Okay. And just so Mr. Davenport knows going forward, will you be staying on his case, or will your new partner, Ms. Feely, be taking over the case, or TBD?
It will actually, I believe it'll go to Miss Feely, but I told him that I will be working with her, but
Sure.
she should be
Your
lead on
partners.
this. Yes.
Okay, got it. I'm just, because that would help explain to Mr. Davenport why you haven't necessarily watched every video and plugged in all the thumb drives. Ms. Patel was starting to climb that learning curve. She left, and then it will be primarily Ms. Feely's job, but you'll be partnering with her as she gets the case ready for trial, or however it's going to resolve.
Yes, Your Honor.
Okay. All right. Let me get the indictment up and we can get started. Okay. When you're ready.
Thank you, Judge. Before Your Honor is Marion Davenport. Judge, he's 18 years old. He was 17 at the time of arrest. He is in no bond status. He's been in no bond status since August 1st, 2021. If my math is correct, that's roughly 283 days. We are asking the court to consider setting a reasonable bond in this case, with, of course, an ankle monitor, curfew, and all of the other conditions that the court sees fit. Judge, he can reside at 1885 Lakewood Avenue here in Atlanta, Georgia, 30315. That is the home of his mother, Ms. Shaquan Halls, who is here present in court today. She is available to speak to the court if the court has any questions about the living arrangements. As the court sees, there's a host of other family members here in support. So he does have a lot of family support in the area. He has one child, a little baby Caleb, who's also here. Judge, he has a 10th grade education. He was most recently, prior to the arrest, gainfully employed at Taco Bell near Georgia Tech. Judge, as you know, substantial amount of discovery. I was able to make my way through a decent amount of it. And there is just one thing that I want to bring to the court's attention for this case. There's a witness named Daryl Washington, who was actually in the parking lot across the street from where the incident took place. And he did give, I think, 2 statements to law enforcement. There's one of his statements in the interview room is that he, saw the tussle happen. He saw the gun fall to the ground afterwards. He made a statement that he didn't believe that it was intentional from his viewpoint. And that, there was a statement made that the decedent unfortunately accidentally shot the firearm. So I did just want to point that out. Of
As in
course.
shot himself.
Yes, Judge. And so I know it's very early.
Washington, that was his perspective as to what happened in the tussle, is that Mr. Colvin shot himself, not suicide, but as a result, when the gun went off, the bullet hit Mr. Colvin.
Yes, Judge. Mr. Washington was in the parking lot of a Church's Chicken, and the incident happened right across the road in the parking lot of a gas station. So we did just want to let the court know that information. And again, we're just asking for a reasonable bond today.
Okay. Do you know who resides with Mr. Davenport's mother, or is that a question I should ask?
I think sisters? Yes.
Okay. Sisters who are school age?
College and high school.
Okay, well, college is still school, but okay. Meaning Mr. Davenport's sisters, not your sisters. So if Mr. Davenport stayed with you, ma'am, and thank you for being here, on Lakewood Avenue, he would be staying with his sisters
Yes, sir.
and you.
Yes, sir.
And is that where Mr. Davenport was staying when this situation happened in July of last year?
Yes, sir.
Okay. All right, thank you.
Thank you.
Mr. Davenport, what high school did you go to through 10th grade?
Harvard High School.
Carver? All right. Ms. Wood, anything from anyone else who's here on behalf of Mr. Davenport?
Judge, I think we're good. Just that there's a large number.
I see many people. Okay, all right.
Oh, that's his grandmother.
Pastor Shirley sat down, this is a baby, and it's mother grandmother.
I'm Dad. Please excuse the outburst. It is emotional. I agree.
It is, and it's excused. Don't worry about it. So that's Caleb.
Caleb, this is baby Caleb.
Yep. Caleb has lots of hair.
Coast Guard.
Okay,
He just ran for mayor, and his wife Denise.
great. Okay. Thank you for introducing everyone.
Thank you.
Mr. Abate,
Good morning, Judge.
good morning.
I would respectfully request at this time you deny Ms. Hunt's motion for bond. For several reasons. The first would be, I would submit to the court that the defendant is a risk of committing felonies pending trial. He did have 2 open juvenile cases at the time of this incident. He had one for possession of marijuana, along with possession of a firearm, and death by receiving was one of the cases, and the second one was a criminal trespass case. He was on, I guess, the juvenile equivalent of bond at the time of this incident. He also, in 2017 and 2019, had 2 adjudications for ungovernable, unruly. I'd also submit to the court that he is a threat or danger to people and the community in general, based on the facts and circumstances. This was, I believe, as Ms. Woods may have indicated, this was a meeting around 6:30 in the evening at a local fast food restaurant to do a gun trade or gun exchange. The victim in this case, Mr. Colburn, was a 15-year-old, and as Ms. Wood did indicate is that Mr. Davenport, 17, so both young kids. And at that time.
Neither of whom could legally have a gun anyway,
Correct.
because they're under 18.
Yes, sir.
Okay.
And Mr. Davenport had been brought to the scene by a friend of his in a silver vehicle. You see the victim, Mr. Colvin, kind of walk up to the car. All of this is caught on video surveillance where there's a conversation about the gun, and then you see kind of a struggle, and then you see the victim get shot, and you can see that the defendant has a gun, and what they're struggling over is the victim's gun. What the witness who was in the car who had brought Mr. Davenport to the scene would indicate that Mr. Davenport went to take from the victim, Mr. Colvin, the gun that they were going to trade, and that's what caused
It was a gun trade.
correct.
Okay.
So, and the altercation was due to the fact that there wasn't actually going to be a trade. It was more Mr. Davenport was going to keep his gun, but he was going to snatch the gun from Mr. Colvin. So as Ms. Woods did indicate, there is a witness from across the street who does see the altercation as well as it's on video surveillance. Whether it's an accidental shooting, I can't speak to that. I know what Mr. Washington did say is I would submit to the court speculation as to whether it was an accident or not, as he wasn't in the mix of the argument. But what I can tell you definitively is that it was a gun exchange that turned violent because of the defendant's actions and, snatching the gun that was never actually going to be, there wasn't going to be an actual trade. It was more of a robbery situation. There are two witnesses very close to the defendant that do identify him through a photograph.
Close meaning they know him, or close as in they were standing closer than the guy across the street at the churches?
Close as in the driver of the vehicle that the defendant leaves, and they're also good friends. And then his significant other is able to see him on the video surveillance and identifies him that way positively.
So it doesn't sound like a whodunit. It's a what happened with the tussle over the firearm, maybe plural. Any ballistics information that shows, I don't even know if any guns were recovered, but that which of the guns discharged?
So there are several shell casings that are found on scene, no gun. The shell casings are still right now pending the analysis from the GBI to see if they were all fired from the same firearm.
So there's more than one shot.
Yes, there's multiple shell casings found. I would agree with Ms. Woods that Mr. Washington says he only heard one shot, which again would be testimony, and the video is pretty clear. So I will.
Meaning the video, per the video, you can tell there's more than one shot.
Yes.
Okay. Because there's audio or because there's a flash?
A flash, there's no audio.
Okay.
But with that said, the number of shell casings that were found on scene, in my opinion, wouldn't match the number of shots that were fired. So I would submit to the court that the extra shell casings, it's in an area where gunfire is not unusual, unfortunately, here in the city of Atlanta. But because of his threat or danger to the community, as well as his risk of committing felonies pending trial, the state would submit to the court that at this time the defendant was not an appropriate candidate for bond. I know he was bond was heard for Judge Cox on August 31st in 2021. He found that the defendant was a risk to reoffend or risk of committing felonies pending trial, as well as a threat to the community in which he resides in. I don't believe that there's any evidence of any change in circumstances. I do understand that the defendant is young and does have a family, and it sounds like a very supportive family. So I don't want to minimize that by any sense of the word. But I will work with Ms. Woods to make sure that all the discovery has been presented and given to her due to the change in counsel, so we don't get behind in the process.
Are you aware of, other than the GBI maybe working on things submitted to the GBI, any discovery you have been unable to get your hands on so that Ms. Wood or her partner, Ms. Feely, wouldn't have it?
No, Your Honor.
Okay.
I will check because it's not in my file currently, but that doesn't mean that it's not on the jump drive. I don't have the jump drive. It would be the autopsy photos, but I will follow up on that.
Okay. Got it. All right, but those are easy to track down. I mean, if the defense doesn't have them, those are of the kinds of things that someone might need, like surveillance footage from a convenience store camera versus autopsy photos. Unless it's that one case with Dr. Henninger and the missing brain, I think we're okay. So,
I think it's a situation.
okay, all right. I appreciate that. Anything from Mr. Colvin's family?
We had spoken to them. They obviously wanted me to relay to the court that they opposed bond. They were unable to be present here today, but we're very aware and were put on notice with a lot of time. So there's not an issue of notice in this issue, or in this case. So they wanted to express that they opposed bond.
Got it. Okay. Ms. Wood, as the move-in, anything you want to say just to wrap things up on behalf of Mr. Davenport?
No, Your Honor.
All right. Well, Mr. Davenport, I have a couple things that I'm confronted with already. I need to do one other thing. Ms. Tucson, do you have any adult criminal history for Mr. Davenport? He has not been legally an adult for very long. It doesn't sound like there's anything from your shop. Okay. Ms. Jackson, anything from the reports you were able to generate in connection with Mr. Davenport that Mr. Abate didn't already cover, or anything you need to correct?
Nothing in addition, Your Honor.
Okay, thank you. All right. Can you check on Carlos or someone from that team? See if they're heading this way. Thank you. So you had a bond hearing in front of a colleague of mine, Judge Cox, a few months ago, and it sounds like he would have heard much of the same. I don't know how many of your family members were there, but I suspect they were as supportive of you then as they are now. And Judge Cox found that bond wasn't appropriate. I'm not in a position to overrule a colleague. I'm not his superior. It's not a lower court ruling. The only way that it would be appropriate for me to modify what Judge Cox ruled on would be if something had changed. And an example would be if Ms. Wood came in here and said, we're ready to go to trial, but the state won't give us this evidence, or the state is being slow with this, or they lost that. Ms. Wood is very straightforward. That's not what she said. It doesn't sound like the state is slow in getting evidence to your lawyers. They are anxious to try this case as well for a different reason. But it doesn't sound like the case is moving particularly slowly as cases are moving in this courthouse during the pandemic. I'm sure it feels slow to you and to your family as they want to see you and hold you and have you back in their lives. But it is actually moving along at a fairly reasonable pace given the constraints we have. It sounds like it's ready for trial, but for a few things that are at the crime lab. So I'm not in a position to change Judge Cox's ruling. I will tell you two things. If we get your case on a trial calendar and the state says we're not ready because we can't find this guy or we don't have that, then one of your two lawyers, Ms. Wood or Ms. Feely, ought to say right then and there, well, if the state's not ready, I'll tell you what should be ready, a bond for Mr. Davenport, because the defense is ready. Now, if your lawyers aren't ready for good reasons, we won't be talking about bond. But as long as your lawyers are ready to go, if the state isn't, then circumstances have changed. And we need to talk about what is the right way to balance all this. But given Judge Cox's findings and the fact that it doesn't sound like what concerned him has changed, what has changed is you've been stuck in jail for a few more months. Your little boy's been growing up without you. And those are all bad things. But the concerns that Judge Cox had don't suddenly evaporate. So what I can do is lean on the state to make sure they're getting those last few things out of the crime lab. That's not a reason to delay your trial. I think what's next is to get your case on a trial calendar so that between now and then, your lawyers can talk with the prosecutor. Maybe there is a middle ground between what a guilty plea to murder would be, life, and the facts that Ms. Wood has helped me understand that this may have been, no one was intending that anyone should get hurt. There was a disagreement that got physical, but when you're physical around guns, real tragic things can happen. And I don't know, it's not my job right now to work through what the evidence is or isn't. That time will come, but that's not today. So that's a long way of saying, I don't think I would be justified in changing Judge Cox's order from late last year. So I'm going to leave it as is, but you've got my commitment that we will move your case to a trial calendar and figure out how to get you that trial, or if you and your lawyers come up with something short of trial, how we handle things that way. Do you have any questions about what I just discussed?
No, sir.
Okay, Ms. Wood, anything else on behalf of Mr. Davenport?
Only if we know if it's on the next trial. Do we know yet?
I don't think so,
Okay.
but what we will do when Ms. Feely's feet are on the ground is sit down with you and Ms. Feely, Mr. Bate, and I don't know who the Whitenauer and a couple of the other specialized units to say, help me prioritize. It's not productive to slap 6 cases on a trial calendar, and I don't know which way to start. If you all commit, these are the cases we can be ready on, then we'll do it that way. But the way it ought to work, if I go back to the summary, is it, I don't want to commit to July, but July-ish, that's going to be our next calendar. We're going to be doing calendars that are only a few weeks rather than the sprawl we just did. So it would be this summer, assuming you and Ms. Feely don't tap the brakes after you consult with Mr. Davenport and his family. I don't get the sense they want it to slow down. So they'll want it to keep moving. Okay. Mr. Abate, anything else in Mr. Davenport's case?
No, Your Honor, and I will speak with Ms. Woods in the next coming weeks to make sure that we can come to an appropriate resolution of this case.
Okay, sounds good. Thank you.
Thank you, Judge.
And thank you, Mr. Davenport's family, for being here. I appreciate the support you have for him. So we've reached out to the interpreter, and we'll hold on that. I'll let Ms. Wood talk with Mr. Jones while we're waiting. You two can finish talking. I'm just letting Ms. Charles know what's next.
Thank you, Adam.
Yes, so the victim's mom did take me up on the offer. She called the next day and basically just wanted to be listened to for 15 minutes, which I did. And it was thank you very much. And she went on her way. So there you go.
Thank you for doing that.
Yeah, no problem. You too. Why don't you chat with Mr. Jones while we wait on the interpreter? And so the only person left back there should be Mr. Sargosa Garcia. Oh, and Fox. Well, Fox is here. So we'll try to track down Ms. Hall.
Okay.
And we will try to track down an interpreter because that's what we need. Fox is here. Great. You guys move quickly back in those warrens. All right. I'm going to deal with email right here. Let's see what's happening. I'm just looking at emails here.
Okay.
I was sad. All these cases that were going to be pleas. Go team. No, it's we got to try it. It's fine. Just what happens.
We might have a few more.
And also to do like. This is a case number. Is this the same person? No, it's you.
Mr. Garcia.
But it has that docket number. And a different birthday. Let me see. Postmates. There's no say that, you can go with this down. Birthdays with them. I remember this looks like. Yeah, that's it. So these are on probation for okay, so we do one more. So it's, so in the computer, it says, but what I have.
Yes. Hey, Albert.
Do you get paid for overtime? What does this overtime thing do? Does it give you more or you're on the clock?
Fill out that form. Let them know the reason why they clock out.
Okay,
So annoying.
it is. Well, thank you for bearing with it.
Yeah, I've been trying. It's really annoying.
Okay,
Just
yeah,
to
so
have
that's what I have.
everything ducks in a row.
So look at the date to make sure it works.
Because they and see that even in the system, it's still just money.
Oh, sorry. Okay, but that's what I have too. Okay.
They did give court reporters a retroactive raise, didn't they? Okay, well, so that's a little make up for the sting of this. Yeah, it's still frustrating.
Paperwork, I'm trying to remember all the forms.
Yeah.
Yeah.
All right, so we have Ms. Hall on Zoom.
Good morning, Your Honor.
Hello, Ms. Hall, how are you?
I am good. How are you?
I'm all right. Everything okay in Judge Whitaker's courtroom?
Yes, Your Honor. My apologies for being late.
No, you got to be in multiple places. We had a few other things to work on. We're down to Mr. Fox, and we need Ms. Wood to pop back in here. And then we've got a plea that requires an interpreter. But all the lawyers have stepped outside. So if you don't mind sitting tight, I mean, you're welcome to come here. You look like you're in your office. You're welcome to come here. You can stay right where you are and do other work, but just don't leave us, because I've asked that we focus on Mr. Fox. If he is in fact in a good frame of mind, we got to try to knock that one out.
Okay, I'll be here.
Great, thank you.
You're welcome.
Good morning, sir. I talked to Adejuan. He says he'll turn the software on for us so we can try it at the appropriate time. Today wouldn't be that day, but the lawyers in here got kind of excited when I described technically how it works. Whether we can actually use it, we'll see. But I thought that was good.
You have it, so it just needs to be, the clerk needs to know how to set it up.
Yep. Oh yeah, we'll have them talk to Ms. Nelson about that.
We did it with Carmen, so we
Right.
went in and trained everybody in the
Yep.
office. We did a little bit of practice that day.
Yep.
And not complicated.
Nope. All right, now it's pouring resources on us. I think what we'll do, even though I told Ms. Hall we were going to prioritize Mr. Fox, we have Mr. Lares here. So if we can track down Ms. Wood, any idea where she went? Okay.
Yeah, she is.
Fox, do you think Mr. Fox is here?
He is, he's in custody. Ms. Wood,
Yes.
we now have Mr. Lares. We also have Ms. Hall and Mr. Fox. And I know I said, hey, we'd do Mr. Fox first, but that's because I thought we'd be waiting still on the interpreter. I think we'll use Mr. Lares while he's here and do Mr. Sargosa Garcia first, unless you tell me we need to do Fox, because it might get complicated if he has to wait.
I think it would probably be best to do the interpreter, because I do need to talk to Mr. Fox before we move forward
Great. Do you need to talk to Mr. Sargosa Garcia before we move forward?
with Mr. Lares.
Okay, if we could bring him out, please.
Good, so.
So no word from Ms. Love yet? Just this morning. I mean, it's only 10:30.
Okay, so. I had blocked. So this is, I don't know, is it easier for you to go through this one or the other one?
Ms. Wood, given what the charge is, if you were thinking you'd fill out the whole plea form, I'm okay waiving that, given this charge, unless the disposition is going to be multiple years in prison. If it's not, then get him comfortable and get you comfortable, but we don't need to execute that form.
Okay, thank you, Judge.
Sure.
I had brought the one, Ms. Patel had a Spanish speaking client in your courtroom a couple months ago, and someone had drafted the Spanish.
We have that, yeah.
Yes, and so that's what I put out. I just want to make sure there was no.
We can go through, I'm fine. If you would like the, Mr. Lares to cover that with him, since it's in Spanish, that may make it relatively quick. If it was the English version, like, let's not do that. So however you want to work it.
Thank you, Judge.
Sure.
Okay. Perfect, thank you.
Ms. Flack, do you remember Sarah Flack? She is a defense attorney now, and she has said she's willing to take a couple of our C3 cases. I don't know, but we should chat with her. I have her email. She went through, there's an organization called GACTL, the Georgia Association of Criminal Defense Lawyers. And Judge Whitaker and I had reached out to them saying, we have cases where we don't have lawyers for criminal defendants. And we thought maybe lawyers who make lots of money would take one for free. And they didn't do that. But I think Ms. Flack is saying she would do it as a C3. I don't know. We need to talk with her. She already identified one, but it was from an old list that I sent them that you had generated. And so our guy may already have been assigned to that case. But she's looking to take murders, which is great. So, and her only request was like, don't make me go to trial right away because I need to get to know the client in the case. Fine, we won't make you do that. So I thought maybe we could get her on the phone and talk about cases that might be available, because I didn't remember off the top of my head what had already gone to that guy. And I think there was a woman who took one case. But Flack is not flaky. If she gets on the case, she'll stay with it and she'll also look it up. So I want to try to take advantage of that. The mystery to me is if she would then need to reach out to the public defender people, not that office, but the state one, to say, I'm volunteering to take the C3 case. Io Ali, it's Ms. Ali, who is nice but dysfunctional and is fighting with GACTL. So I tried to, well, I don't know. So I need to find out. We need to find out from Ms. Flack. Was she just saying, I'm gonna do this out of goodness of my heart? Or she was saying, I'm willing to be a C3 lawyer. And then what I would do is say, don't mention GACTL. I'll reach out to Ms. Ali saying, look, I found a good defense attorney who's willing to do some C3 cases. How can we make that happen? And she may say, it can't happen. And then it's nice that she's volunteering. But she may have been saying, look, I don't need to be paid for this. I'll just do this. But I just remember she's real nice and smart, and that'd be great. Exactly. That's the point I'm at.
La dirección de mi audio. Esa es una dirección que se puede enviar los papeles.
Do we have the accusation numbers for Fox? Or do you need to get that? Ms. Hall, can you send through chat or email to Ms. Nelson whatever the accusation numbers are for Mr. Fox?
Yes, Your Honor, I'll do that now.
Thank you.
You're welcome.
Allanamiento de lugar en segundo grado. Para servir 3 años, a 2 de esos 3. Como reconozco el crédito que tengo tenido, la diferencia en libertad. Emisión de puntos de una decisión voluntaria de mi parte. No se me ha prometido nada diferente como puedo tomar. Nadie me preguntó de responder ninguna para tomar esa decisión. Todas los derechos gratuitos no tomando los estoy indicando la voz que entiendo que de acuerdo con esta declaración. Si no entiendo que estoy de acuerdo con ninguno de estos enunciados, he visto una copia de la imputación de documentos acusatorios, entiendo los cargos que le dejé en mi copia por los delitos cometidos. Y acá ese es el instrumento y entiendo que parece la mayoría en contra por los delitos acusado de crearte una casa o un negocio de la cual tengo derecho a declararme los culpables fiscales. Tengo derecho a si me declaro un culpable, si el hijo que viene en juicio, tengo derecho a que sea un juicio controlado. Y el controlado presenta si ese juicio tengo derecho a ser representado por un abogado, aunque no pueda pagar. Un abogado se me presume inocente durante el juicio, que es la fiscalía que tiene la obligación. Se le ha hecho la obligación. Un abogado de carácter que se han presentado para declarar en mi contra. En ese juicio tengo derecho a declarar. Y ese es el derecho de silencio. Nadie puede forzarme. Nadie puede comentar que no lo hice, como hecho en mi contra. El juicio tenía que presentar otras pruebas adicionalmente a mi declaración de la que estuviera pero aquí están escritos. Pero en ese juicio tengo derecho a citar y compeler testigo para que declaren en copia o que lo pudiese. Si me declaro culpable, como hace renuncio a todos los derechos, no tengo derecho. Lo único que quedaría pendiente sería la única, que es hoy. Si me declaro culpable, tendría muy poco que apelar después de 6 meses antes de yo. Después encuentro que mi derecho fueron sustancialmente afectados por este proceso de sentencia negociada, puedo introducir una petición aleatoria. Tengo 4 años a partir de la fecha de mi sentencia, introducir dicha solicitud, si es por delitos mayores de felonía, y años si es por delitos menores. ¿Qué necesito? Se habla sobre el derecho de tratar, es decir, retirar comisión de conflictivo negocial en la acción que entiendo se refiere a medición de you have 2 rights, 2 different ways of this rule. My attention on the trying to define a case, establish even the need to provide because it's yeah, final recommendation. Yes, basta, porque inicialmente esta definición de la fecha o antes al último día establecido legalmente profesional. Entonces, aquí vas a poner, ¿qué punto? Que yo diga que inicial, entonces, de imposición de sentencia. El mismo enunciado, el enunciado, el enunciado, estoy indicando lo que entiende y de acuerdo con entonces,
Yeah. Thank you.
Examen, segundo, beneficio, diferencia de los planes que queda muy supervisión. Maximum time to serve. Máximo servicio, el ejercicio igual. No me fuerzas.
This one does not.
Como parte de la misión de puntos, que sea y la comisión. El número de llega bien completamente un palo tomando esta decisión porque soy culpable. No,
Oh, okay.
This 2 minutes belongs to.
Okay.
But this one says 3 minutes.
Okay. Let me ask her if she has any objection. Okay,
Are we getting close, Ms. Wood?
yes, Judge, we've altered the negotiation.
Ooh, real time. Okay.
Yes, I'll change it. Thank you, Judge. Okay. I'll change it. Thank you. Okay.
Por conveniencia, según el concepto tal, o si se encuentra directamente.
Did you get the file numbers from Ms. Hall?
Yes, it's on the.
Just one? Okay, great.
Okay. Perfect. Yes, that's it. Oh, Judge said we don't have to sign it. We just wanted to read through it.
Okay.
That's totally fine.
Does it need to sign?
I can, yeah, I'll sign.
Even entonces en esta línea.
Thank you. I so appreciate it. Awesome. I can do it. I'll do it. While we're sitting up there. Thank you. All right, Judge, we're ready.
Great. Ms. Rivers, you ready? All right. Ms. Charles is assuming her spot.
Párate aquí. Hablar al micrófono.
This is position 21 SC 180051, State versus David Sargosa Garcia. Mr. Lares?
Contra el señor David Zaragoza García.
If you'd raise your hand, do you swear or affirm that you will translate from English to Spanish and Spanish to English to the best of your ability and according to your professional training?
I do, Judge, to the best of my ability.
Great. Good morning, Mr. Sargosa.
Good morning, señor Zaragoza.
We're going to use the interpreter, which means before you answer a question, even if you understand the English, please let Mr. Lares translate it to Spanish.
Dice, vamos a utilizar al intérprete, yo. Dice, aunque creo que entiendes el inglés, deja que el traductor te traduzca de todas maneras lo que se dice en inglés, aunque lo hayas entendido. Okay? Very well.
You should answer the questions out loud in English or Spanish, but then Mr. Lares will repeat what you said in English, and that will be the official answer, okay?
La respuesta oficial va a ser la que yo como intérprete dé. Tú puedes responder si estás entendiendo en inglés o en español y yo traduzco, pero la respuesta oficial es la que yo digo.
Sí.
Yes.
If at any time you cannot understand what someone is saying or you have a question, please let Mr. Lares know.
Si tienes alguna duda, alguna pregunta, no entiendes algo en el proceso, déjamelo saber para yo avisarle a tu abogado.
Okay.
Okay.
Ms. Charles is going to put you under oath in just a minute.
La señora fiscal, que es la señora Charles, te va a juramentar para que entonces puedas declarar, ¿ok?
Once you're under oath, it's important that all your answers are truthful.
Es importante que después que te juramenten, tus respuestas a todas las preguntas que te hagan sean verdaderas. Yes, Judge, maybe he needs to be instructed to respond yes or no, because all his responses are
Sure. So, is it Senor Garcia, Senor Sargosa or Senora, Senor, Sargosa Garcia?
¿Cómo se le debe decir? ¿Zaragoza García o Zaragoza? ¿Cómo?
Zaragoza García.
Zaragoza García.
Okay, we'll use the whole thing. So, Mr. Sargosa Garcia, when you're answering a question, it needs to be sí, no, or something more, but not because Mr. Lares needs to know that you said yes, even though you're nodding your head and you say it needs to be yes, or I think so, or whatever your answer is. It needs to be words.
El juez te dice, señor Zaragoza García, que cualquier respuesta que des a las preguntas que te van a hacer debe siempre responder sí o no, o entiendo o no entiendo.
Okay.
Soy yo como intérprete,
Sí.
que voy a reportar la respuesta, tengo que escuchar de ti la respuesta que debes dar a la pregunta.
Sí.
Yes.
Great, let's get started.
Ok, vamos a comenzar entonces ahora.
Good morning, Your Honor. Before we
Buenos días, su
proceed
señoría.
with the
Antes de que
indictment,
procedamos con la sentencia,
we would like to reduce the
quisiéramos
current charge
reducir
from
uno de
burglary,
los cargos de
first degree,
allanamiento en primer grado a allanamiento
second degree.
en el segundo grado.
Is that still a felony?
That is still a
Sigue
felony.
siendo
Does that mean it's a business as opposed to a residence, or what's the difference if it's a residential burglary? Because it says dwelling house in the indictment.
En el documento acusatorio parece que es
we
una
were-
casa que supuestamente él se metió.
We were concerned as to the manner of entry in this particular
Estamos
burglary.
reduciendo
There was
con
no
respecto
forced
a lo que
entry,
entendemos
and
el
looking at
índico
the gravity of the crime, we thought
cuando entró a la casa
second
y la
degree
manera como entró. Entonces,
it's the
por eso lo
facts
estamos
better than
reduciendo a
first
segundo
degree.
grado.
Okay, burglary in the second degree.
Ustedes no entienden. Entonces, allanamiento de una morada, pero en segundo grado.
Mr. Sagosa Garcia, please raise your right hand.
Por favor, señor Zaragoza García, levante la mano derecha como pueda.
Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
¿Juras o afirmas que la declaración que estás a punto de dar en este caso que está ante el juez va a ser la verdad, toda la verdad y únicamente la verdad?
Sí.
Yes.
You may lower your hand.
Puedes bajar la mano.
Please state your true, correct, and legal name.
Danos por favor ahora tu nombre completo, tu nombre correcto, tu nombre legal.
David Zaragoza García.
David Zaragoza García.
Sargoza.
Zaragoza.
Please spell that for the record, please.
¿Puedes deletrearlo?
Sargosa. Sargosa. No sé cómo se llama.
Sargosa. Zaragoza. Is here.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
¿Estás en estos momentos bajo los efectos de alguna droga, algún medicamento? ¿Estás tomando algún medicamento para él?
No.
No.
How old are you and how far have you gone to school?
¿Cuántos años tienes y hasta qué grado de escuela llegaste?
39 y nomás la secundaria.
39 and I only finished secondary level school.
Are you able to read, write, and understand the English language?
¿Puedes leer, puedes escribir, entiendes el idioma inglés?
No,
No.
Do you understand that you are charged with the following offense? Burglary in the second degree?
Has sido acusado, en este caso, por allanamiento de una morada, ahora en el segundo grado. ¿Entiendes eso?
sí,
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a trial by jury.
¿Entiendes que tienes el derecho a declararte culpable a los cargos o permanecer por estos cargos como no culpable? En cuyo caso, si te hubieses quedado como no culpable, por ello hubiésemos tenido que entonces tener un juicio por jurado. ¿Correcto?
sí, sí, sí.
Yes, yes, yes.
Have you reviewed the waiver of rights form of your attorney?
¿Revisaste ahorita el documento de renuncia de derechos con tu abogado?
Sí,
Yes.
Have you had enough time to speak with your lawyer about all of the facts and circumstances known to you about the charge in this indictment, including any potential defenses?
¿Tuviste ocasión de hablar con tu abogado sobre las circunstancias, los hechos que generaron este caso, conocidos por ti? Cualquier defensa que hubiese podido ella levantar a favor tuyo por ello?
sí.
Yes.
Do you need more time to discuss the case with your attorney?
¿Necesitarías más tiempo para conversar con tu abogado ahorita sobre el caso?
Pienso que es bien.
I think so.
No.
Sí.
Yeah, yes.
Oh,
Yes, so
sí,
¿Necesitas más tiempo para hablar con ella sobre el
sí,
caso?
sí, a ver, sí,
¿Necesitas?
poquito más. No.
I need to a little bit more.
okay, so can we step back here?
Párate
and
aquí
you
entonces.
can- One moment.
No problem.
¿Cuál es la pregunta?
Que si pues, voy a pagar con cárcel, nada más tiempo, voy a salir ahorita.
If I'm going to pay with more time, I'm not going to be released.
Give me some time, sir.
La sentencia como ya se tenía, es tiempo cumplido.
No,
So he'll be released whenever the job gets in.
Debes a ser liberado de la cárcel y que la cárcel reciba la documentación para ello.
oh, está,
And it's usually within 24 to 48 hours.
Usualmente tengo de 24 a 48. Pero bueno, sí.
And we'll be able to tell the judge when it's my turn to speak, we'll be able to give him a little bit more information. The events.
Entonces, decirle un poquito más sobre lo que sucedió. Que tú le dijiste que tú pensabas que la casa era la casa de un niño.
pues sí, pienso que
Exacto.
This whole Paul Heist thing was bizarre. Some guy from Pep Boys shows up.
We're ready, Judge.
Okay. Mr. Sargosa, did you have enough time to speak with your lawyer about the question you had?
Señor Zaragoza, ¿tuvo usted suficiente tiempo entonces para hablar ahorita con su abogado sobre la pregunta que tenía?
sí,
Yes.
Are you ready to go forward?
¿Estás entonces listo para continuar?
sí.
Yes.
Okay.
This one, do you waive formal reading? of
Entonces
the
le
indictment?
pregunta a tu abogado si renuncia a tener que leer formalmente el documento acusatorio en esta audiencia.
Ujú.
So waived.
Ella dice
Do you waive
renuncia.
all defects in the indictment?
Y renuncia a tener que corregir el documento acusatorio si hubiera algún error.
So waived for purposes of this hearing.
Ella dice, por esta audiencia renuncio a tener
Zaragoza
que
Garcia,
corregirlo. Señor
were
Zaragoza
you
García,
arrested on these charges?
¿a usted lo arrestaron cuando lo detuvieron?
Sí,
Yes.
The state is unaware of any outstanding warrants
Dice-
related to these charges. Do you or your attorney know of any outstanding warrants that are related to these charges?
Ella dice, ¿sabe usted si queda pendiente, abierta contra usted, o su abogado sabe si está pendiente contra usted o existe contra usted alguna boleta de arresto por estos cargos?
no, nomás lo que me dio el policía, el resto de policía. ¿No?
No, only what the police officer gave me. The rest came from.
So no, we do not.
Ella, entonces tu abogado dice, no sabemos.
Has your attorney advised you of the minimum and maximum sentence for the charge you are pleading to today?
¿Te ha informado tu abogado sobre el mínimo de tiempo a servir por este cargo, el máximo de tiempo a servir por este cargo al que ahora estás admitiendo culpa?
Sí.
Yes.
And for the record, based on the reduced charge of burglary, the second degree, the minimum and maximums are 1 to 5 years.
Dice para que conste en la acta de la audiencia del acusado, este delito al que le está admitiendo culpa ahora, allanamiento de una morada en segundo grado, está penado con un mínimo de 1 año, con un máximo de 5. Yes.
Do you understand that this is a negotiated plea of guilty?
Esta es una sentencia negociada entre ella y su abogado. ¿Entiendes eso?
Sí.
Yes.
Which means the state will recommend to the court a sentence of 1 year to serve, commuted to time served.
Y eso significa que yo le voy a recomendar al juez que lo sentencie a usted a 1 año, reducido ese año de pena de cárcel al tiempo que ya usted pagó.
Sí.
Yes.
But the court does not have to accept this recommendation.
Ahora el juez no está obligado a aceptar la recomendación de pena que ella le va a pedir que imponga. ¿Entiendes eso?
Sí.
Yes.
The court can sentence you to the maximum on this charge.
Puede el juez, si rechaza mi recomendación, sentenciarte al máximo que la ley le permite a él sentenciarte.
Sí.
Yes.
You understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including the federal courts.
¿Entiendes que esta admisión de culpa puede ser utilizada para, si tienes algún otro caso pendiente en algún otro lugar o aquí, incrementar la pena que pudieran imponerte por ese otro caso aquí?
Sí.
Aquí o inclusive en tribunales federales.
Sí.
¿Entiendes eso?
Sí.
Yes, yes.
Do you understand that if you are not a United States citizen, this guilty plea will affect your immigration status and will almost likely result in deportation, just like a conviction at trial would?
Debes entender que si no eres ciudadano norteamericano, tu admisión de culpa va a impactar tu estatus de inmigrante en el país. Inclusive, tu admisión de culpa pudiese generar tu deportación de este país. ¿Entiendes eso?
Sí.
Yes, yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction after a trial?
Debes entender que también tu admisión de culpa va a generar otras circunstancias adversas, desfavorables, tal y como si hubieses tenido un juicio y hubiese terminado el juicio, hubieses perdido el juicio.
Sí.
Yes.
For example, your guilty plea may affect the right to vote.
Por ejemplo, circunstancias adversas. Tu admisión de culpa pudiese impactar tu derecho a votar aquí,
Sí.
por ejemplo. Yes.
The right to hold public office, the right to serve on a jury, and the right to obtain a passport.
Igualmente afectaría tu admisión de culpa tu derecho a ser político, a tener una oficina pública.
Sí.
Tu derecho, si fueses americano, a participar como miembro del jurado.
Sí.
Tu derecho, si fueses americano, a solicitar un pasaporte.
Sí.
Yes.
The right to receive, possess, or transport a firearm, or the ability to obtain employment.
Inclusive pudiese afectar tu derecho a transportar, a comprar, a tener armas de fuego, inclusive a conseguir trabajo.
Sí.
Yes.
Do you understand that pleading guilty to a felony if you use, receive, or possess, or transport a firearm?
¿Entiendes que si por admitir culpa a una felonía, luego estás en posesión de un arma de fuego, o compras un arma de fuego, o transportas un arma de fuego,
You will be guilty of a felony which may carry a sentence of 1 to 15 years in prison.
terminarían encontrándote culpable de una felonía que estaría penada con un mínimo de 1 año a 15 años de presidio.
Sí.
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Entiendes que por admitir culpa renuncias a cualquier defensa que hubieses tenido por lo que hiciste, inclusive a solicitar una defensa por problemas mentales.
Sí.
Yes.
Do you understand that by pleading guilty, you're giving up the following rights?
Debes entender entonces que por admitir culpa ahora vas a renunciar a los siguientes derechos.
Sí.
Yes.
The right to trial by jury,
El derecho a haber tenido un juicio por jurado.
Sí.
the right to remain silent and not incriminate yourself,
El derecho a permanecer en silencio, a no incriminarte.
Sí.
Yes.
the right to confront witnesses against you,
El derecho a encarar, a confrontar los testigos que hubiesen venido a declarar en tu contra.
Sí.
Yes.
the right to assistance of counsel hired by you,
El derecho a haber sido asistido por a un abogado contratado por tus propios medios.
Sí.
or
Yes.
or to court appointed counsel if you cannot afford an attorney.
O un abogado que el tribunal te hubiese tenido que asignar porque no hubieses tenido los medios para pagarlo.
Sí.
Yes.
The right to the presumption of innocence,
El derecho a que se te presuma inocente.
Sí.
the right,
Yes.
the right to testify on your own behalf and to present other evidence,
El derecho a declarar a tu favor y a presentar pruebas diferentes.
Sí.
Yes.
the right to subpoena witnesses and compel the production of evidence,
El derecho a hacer comparecer por orden del tribunal a cualquier otro testigo que se hubiese rehusado a hacerlo y a presentar diferentes pruebas.
Sí.
Yes.
the right to have the charges against you proved beyond a reasonable doubt,
El derecho a obligar a que los cargos que levantaron en tu contra hubiesen sido probados más allá de toda duda razonable.
Sí.
Yes.
the right to appeal if convicted of these charges after trial,
Y el derecho de apelar a estos cargos si hubieses tenido un juicio y lo hubieses perdido.
Sí.
Yes.
has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
Te forzó a alguien, te amenazó a alguien, te prometió a alguien a ti alguna cosa para que tú decidieses admitir hoy culpa.
No.
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Es tu decisión renunciar a estos derechos, admitir culpa a estos cargos porque de hecho eres culpable del cargo que se te levantó.
Sí.
Yes.
How do you plead to the charge of burglary in the second degree in indictment 21 SC 180051?
¿Cómo te declaras entonces ahora al cargo de allanamiento de una morada en segundo grado bajo el caso número 21 SC 180051?
Culpable.
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Estás entonces ofreciendo tu admisión de culpa de una manera libre, de una manera voluntaria, con pleno conocimiento de lo que estás haciendo.
Sí.
Yes.
Do you understand that you may only have a limited right to appeal this guilty plea conviction?
Te queda un derecho limitado para apelar tu admisión de culpa y la convicción que genera la misma.
Sí.
Yes.
Do you understand that you only have 4 years from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Se te da a partir de hoy, por delito mayor, 4 años para introducir una petición que se llama habeas corpus, la cual, si la introduces, se opondría a tu admisión de culpa que hoy ofreciste.
Sí.
Yes.
Your Honor, the state is aware of one prior
Dice,
conviction
la
for
fiscalía dice,
Mr. Zaragoza
solamente
Garcia,
conocemos un antecedente penal que tiene el señor Zaragoza.
which is out of Carroll County in
Es el
2006,
Town
theft by taking.
County en el 2016 por haberte
Can you give me
por haber
that
estado en
year
posesión
again?
de algo robado.
And that's a felony?
2016. Le
Okay.
preguntó,
Got it.
¿fue una felonía la que él en el 2016 recibió? Y dice la fiscal, sí, es un delito mayor.
And had this case proceeded to
Dice,
trial,
entonces
the
si hubiésemos
state would
tenido
expect
un
to
juicio, la
show
fiscalía hubiese demostrado
that on
que
December
el
29th,
29 de
2020,
diciembre del 2020,
officers responded
los oficiales fueron despachados al
Carroll Street,
201 Carroll Street, aquí en Atlanta, Georgia.
that was being occupied
Eh,
by
vieron
3 roommates,
que había, esa casa la ocupaban 3 personas que vivían juntos allí.
Michaela Henderson,
Michaela
Caroline
Henderson,
Braun,
Caroline Blond
and Mohammed Munier,
y Mohamed Monier.
YE. Miss Henderson
La señora
heard
Henderson
someone
escuchó a alguien
walking around
caminando dentro de
their
la casa.
home and
Y
she alerted
ella
Caroline
despertó a Carolina.
and they went into the bedroom.
Entraron ellas en
Called the
el
police.
cuarto donde dormían y ahí llamaron a la policía.
Mr.
El
Monnier
señor Monnier
hid in the bathroom.
se escondió en el baño.
While they were in the bedroom,
Estando ellas en la habitación,
they felt someone trying to enter.
sintieron que alguien
They
estaba
used
tratando de
their
abrir
weight
la
to
puerta
stop the door from opening.
y trató de abrir la puerta que ellas habían cerrado.
At this point,
En
officers arrived
llegaron los oficiales para ese momento
and were confronted with Mr.
y encararon
Garcia,
al señor Zaragoza García,
who
quien
at the time they noted
en ese
had a
momento
hospital band around his arm.
notaron que llevaba en la muñeca de una de las manos una tira de
Was he
un
found,
hospital.
Mr. Sargosa, in the house or outside the house?
Dentro de la casa
Okay.
o afuera de la casa. Afuera fue que lo encontraron.
Officers had
Los
a Spanish-speaking officer
oficiales
respond,
hicieron entonces que llegara un oficial que hablara español.
and
Y
Mr. Sagosi Garcia
el señor
confirmed
Zaragoza
that he
García
had entered the property.
confirmó, les admitió que había entrado en esa casa,
He had rummaged around
que
the
había
property,
caminado dentro de esa propiedad que no era de él,
and in fact, he had
y de
taken some
hecho
boots
se había
belonging to
llevado
Mr. Mohammed
las botas
Monnier
del señor Mohamed Monnier,
that he was wearing.
que las tenía inclusive puestas ya.
Mr. Garcia left his
El
old
señor
shoes in the
García
apartment.
se quitó sus propios zapatos y los dejó dentro de la casa de ellos.
Mr. Monnier was
El
able to
señor
identify the
Monnier,
boots as his
cuando
work
salió,
boots.
pues pudo reconocer que tenía usted sus
And
botas
Mr.
puestas.
Garcia was arrested and
Y en
taken.
eso fue entonces detenido y arrestado el señor Zaragoza García y acusado por haber entrado ilegalmente en la casa de ellos.
To date, Mr. Sagosa
Para la
Garcia has
fecha de hoy, el
served
señor
498 days in
Zaragoza
custody.
García ha estado preso 498 días en nuestra cárcel.
Why we
Por eso es que
recommended time served,
recomendamos
as
que
well
le
as
den
noting
tiempo
the only items taken
servido,
at the time were the boots. And
ya que
officers
lo
after
único que
that's in
se
the area
robó
of
fue
those
las
who rummaged
botas
through the apartment and the utility
y
closets and area near the television. There was nothing further taken. And they
pudo
had
él haberse llevado algunas otras cosas que estaban dentro de la casa, pero que él
And it sounds like from the victims,
A mí me parece que
Mr. Sargosa didn't assault or threaten them other than
no
being in their house. It wasn't a violent or tumultuous encounter.
hubo violencia,
Okay, just frightening.
un problema de allanamiento
Okay.
de morada,
Sí, se ponen los zapatos.
So no restitution
no-
and no victim impact statement beyond you relaying what you've already shared.
Como parte de lo que ya usted conversó conmigo, le pregunta al juez a la fiscal, le dice correcto.
Ms. Tucson, anything else on Mr. Sargosa's history besides that Carroll County
El
conviction?
historial del señor
And is
Zaragoza,
that
aparte de lo que ya sabemos,
no
del
active
lado
probation?
arrestado,
Okay.
no tiene él libertad. por
Ms.
eso.
Jackson, do you have anything concerning Mr. Sargosa?
Si tiene algo que decir sobre el señor Zaragoza, es la señora.
One misdemeanor that was in 2018 for disorderly conduct.
Otro delito menor en el 2018.
Was that in Fulton County?
fue reducido
Yes, Your Honor.
a preguntar al juez.
All right.
Eso aquí
Thank you.
inciso, señoría.
Yes, sir.
Ms. Charles, did law enforcement or you figure out what the hospital band was for?
Supieron de qué se trataba esa cinta de hospital que él llevaba en la muñeca. Dice que no. Tenía él una cortada en el brazo,
Okay.
según
Got it.
dicen los oficiales,
Ms. Wood.
estaba sangrando de
Thank
esa
you,
cortada.
Judge.
Entonces, la
Mr.
señora
Sargosa Garcia
el señor
is 39
Zaragoza
years
García
old.
tiene
He has been in
39
custody
años de edad,
498
tiene
days.
preso
I
498
did want to
días.
know part of
Quiero
the
decirle
reason that
a
it's
su
been
señoría
so
que la
long
razón
is
por la
the
cual
first.
tardó tanto
So when it
esto
was
fue
in
que
pre-indictment all of last year, there were
él fue
issues
acusado el
finding
año pasado,
a good
hubieron
contact for a
problemas
family or a
de
friend
encontrar
that
para
could
él
help us kind of
alguna
put the
amistad,
puzzle pieces
alguien
together.
que
I
pudiéramos
recently, within the past
utilizar la
month,
dirección.
found a family friend in
El año
Snellville
pasado
who
encontré a
is
alguien,
confirming
amigo de
that
la
he
familia
can
de
come live with
Snellville,
him in Snellville.
y nos dio
Mr.
la
Sargosa
dirección del
Garcia
señor
has
Zaragoza
done,
García.
sorry,
No, coge. Yeah.
Oh,
One second.
has done work in the construction industry, and that's what he'll
Estaba
be
trabajando en
returning to.
construcción.
So we would just ask the court
Solamente le pedimos a su
to accept this
señoría que
recommendation.
acepte
And
la
just to add,
sentencia,
Judge,
y
there was a
solamente para
statement, he
agregar,
made a statement
él dio
on
una
scene.
declaración en lugar de los hechos.
So it was 1 a.m. in the morning around the holidays.
A la 1 de la mañana.
Like he'd been out of town. He was told to meet up with an old friend
que
there, so I
un
think there
amigo
was a
y al que iban a
miscommunication in the
encontrar allí.
address, so that is why he was at his
Que
home,
esa fue la
Judge.
dirección.
Meaning he was supposed to be somewhere on Carroll Street and maybe he landed at the wrong dwelling.
Yes, Judge,
Terminó
his
entrando en la casa
address at the
equivocada.
time,
Sí,
I don't remember the exact distance, but I looked it up. It was like less than a
Claro, que
mile
era menos
from
de
the
una
Carroll
milla
Street address.
de esta
Okay.
dirección donde a él lo arrestaron.
Mr. Sargosa Garcia,
Señor Zaragoza García,
do you understand that this plea that you're entering could result in you being removed from the United States?
¿entiende usted que esta negociación de sentencia de la cual acaba de participar puede ocasionar que lo remueva de los Estados Unidos?
Sí.
Yes.
Has anyone promised you that you would not be deported or removed as a result of this plea?
¿Alguien le prometió a usted que no va a ser entregado a inmigración, removido o deportado?
No,
No.
And where were you born?
¿En dónde nació usted?
en México.
En México.
Okay, so that could be where you are sent back to as a result of this guilty plea. You understand?
¿Entiende que pudiese usted terminar de regreso a ese país por causa de su admisión de culpa?
Sí.
Yes.
And understanding that, do you still want to go forward with your plea?
Entendiendo que ese puede ser el efecto final de su negociación, ¿desea continuar entonces con este proceso?
Sí.
Yes.
Do you have anything you want to tell me?
¿Tiene algo que decirme?
No, pues,
No.
Okay. Well, Mr. Sargosa Garcia, I find there's a factual basis for your plea.
Pues, señor Zaragoza García, entonces encuentra que hay base legal para aceptar esta negociación.
sí.
Yes.
I also find that your plea is knowing and voluntary.
También encuentro que usted está negociando con conocimiento de causa, de forma voluntaria.
Sí.
Yes.
Do you have any questions about anything anyone has said?
¿Tiene alguna pregunta sobre lo que cualquiera de los que estamos aquí haya dicho?
No, pues, que me disculpen que estaba.
No, but please forgive me for it.
Okay, I'm not the one who needs to forgive you. It would be the people who lived in that house. Hopefully they've moved on. That was a year and a half ago.
Yo no soy quien debe pues perdonar lo que hizo. Quizás las personas que estaban en esa casa, quien asustaste, que quizás ya no están allí.
Sí.
Yes.
You are lucky you didn't get shot. This is Georgia and people keep guns in their houses in case something like this happens.
Dice, tienes suerte que no te dieron un tiro. Estás en Georgia. Hay personas que guardan armas de fuego
Sí,
justamente para defenderse.
Sí, es lo que estaba pensando, lo que me dijeron, pero gracias a Dios no hice nada. Y sí.
Yeah, that's what I thought. I was told that too, and thank God that I didn't do nothing.
Everyone turned out okay.
Pero bueno, todos salieron bien de este suceso.
Okay.
I am going to follow the recommendation. I will sentence you to 1 year to serve. You've already served that 1 year plus some more. So you should be released today or tomorrow.
El juez dice, voy a aceptar entonces la recomendación de pena que me hizo la fiscal. Voy a sentenciarte a 1 año. Ya serviste ese año y más días del año. Así que por ello debes estar a punto entonces al llegar a la cárcel de salir.
Okay, sí.
Okay, yes,
Gracias.
thank you, thank you.
I'm going to ask Ms. Wood to check by the end of the week to confirm that you were released, assuming there's no hold on you.
Voy a pedirle a la señora Wood que al final de esta semana chequee si te soltaron de la cárcel, asumiendo que no te esté solicitando ninguna otra agencia policial.
Sí.
Yes.
Ms. Wood, normally I'd have your client bear that burden, but I worry that Mr. Sargosa might have difficulty connecting with you because of the language barrier.
Que, bueno, ya que el señor Zaragoza no habla inglés, se mantenga en contacto con usted para determinar si lo soltaron o no.
So Ms. Wood, please let me and Ms. Nelson know if by Friday, Mr. Sargosa is not out.
Yes, Judge,
Le
I
dejes
will.
saber a él si no te soltaron, porque si no, entonces él hace una orden especial.
Ms. Charles, anything else?
Preguntan a la señora Charles si hay algo más, y ella dice que no.
Ms. Wood?
No, Your Honor.
La señora
All right,
Wood,
thank you.
tampoco. Eso es todo entonces. ¿Ok?
Gracias, señor juez.
Thank you, Your Honor, he says.
Here, put
De
this
nada.
together, paper.
De nada.
That's my number in there.
Thank
okay?
you so
Tiene el
much.
You're
teléfono de ella,
welcome.
entonces, ¿ok?
Take care of you.
Espera que te suelten, ¿ok?
Before we bring Mr. Fox out, what are we doing with Mr. Jones?
Judge, I have I'm gonna update his address. I do have a good, new address. He's unsure of how it got changed. He does live here in Atlanta, so I'm gonna get that updated. So he just wanted the court to know he did not willingly miss court.
What did he miss? Was it plea and arraignment?
Arraignment.
Okay.
So
Will your office be able to represent him?
at this time, Judge. Yes, so I will enter a plea of not guilty and ask the judge to set aside the bench warrant and let him go on his way.
Okay. So Mr. Jones, did you leave Ms. Wood with a good phone number for you?
I did. I left her with my direct cell phone as well as my updated address and apartment number.
Okay. And what was in the system? Something in Philadelphia? Do you have friends or family in Philadelphia?
I moved here in November 2020 and my license, I guess when I got pulled over, it was still Philadelphia.
Got it. So you have a connection to Philly. That's not just made up, that you are from there.
I am.
Okay.
I've been here for about a year now.
Are you working?
Yes, I own a women's clothing line. It's an e-commerce business.
And you're able to represent Mr. Jones. It's just currently not a super successful women's clothing line business, or?
When I first came here, I started event management, party promoting. It was kind of up and down. It wasn't that great. So I started my own business. I'm kind of fluctuating.
Okay, I wasn't being critical. I just want to make sure. Ms. Wood wants to help everyone, but folks who can help themselves, get their own attorney, need to do that because we've got very limited public defender resources. But if at this time you think it's appropriate for your office to represent Mr. Jones, then that's what it will be. You'll file the entry, the waiver of arraignment, whether it's you or Ms. Feely who ends up keeping the case, we'll at least be able to move it forward. We'll get a scheduling order in place and Ms. Charles can take it from there.
Yes, Judge.
All right. Mr. Jones, I'll lift the bench warrant and you are free. You don't need Mr. Jones to stick around.
No, Your Honor.
All right. Don't be scarce. All right.
Judge, do you want me to pop back and check on Mr. Fox before we move?
Please
forward?
do. Yep. And come back out with the thumbs up or
Yes.
whatever it is. Ms. Hall's ready.
Yes.
Thank you, Ms. Charles, for your help. Hey, so Monday, it is looking like, is Nunez. How's it going with you and Mr. Mann?
We have not spoken yet. She comes back into town today.
All right, well, it gives him a little while to get ready. Sounds like it's a simple case. People show up, it's a robbery, and the rest is history.
Sounds like it.
Okay, you'll be ready,
I'll be ready.
but I don't want you to be unnecessarily running full speed to get ready. So please do, we'll try to reach out to Mr. Mann as well. I suspect he's going to say, oh my gosh, not your problem. Frankly, really not my problem. But we don't need to try the case only to have it returned to us on ineffective assistance. I know a little more about it based on the plea litany with Ms. Lira. So Mr. Mann needs to engage. I assume his discovery is just gathering dust on the.
Waiting for us.
Okay. Well, so at a minimum, he and his client will be showing up on Monday morning. I will let you know before the weekend what's going to happen. We're not going to make jurors show up if it's just going to be me lecturing Mr. Mann. But Carr was ahead of that, but we can't do Carr because with Owens, your alleged victim, is in federal custody.
Yesterday, he came out, he was able to give me some updates as to his status in federal custody. So he took a plea on April 28th. The sentence is now scheduled for 7th of July. So he's going to help me work. We're going to try to reach out this week again and see if he can be produced on the after sentencing would be able to produce. I wasn't sure what the accounts are, so we'll find out.
Okay, let's progress. Carr's not in jail, is that? Okay, so that's a little less of a crisis, although I think he's filed a speedy, if I'm remembering correctly. It doesn't run right now because it's been told, but that's a reason to move that along. I think those were your two cases for Monday, Carr and Nunez. All right, well, let's all of us try to reach Mr. Mann. I guess his inbox will be full. Hopefully he does something with it. All right. If Mr. Mann says, hey, I have the speed of Mercury, I can be ready on Monday, you can be ready on Monday?
Yes, Your Honor, everyone's subpoenaed to the victims of Dawes, so it's a matter of just.
Okay, all right, thank you.
Oh, I will say, Your Honor, my main detective is currently in Arizona. She's doing a trial there, and Detective Dickinson of the Roswell. She's going to be back on the 15th, but she'll let me know if anything changed. She works with special needs.
And she's in Arizona.
Yes.
Okay. Well, coming back on the 15th is great because 16th we pick a jury anyway, so she could get over her jet lag and be ready to go. All right. Thank you.
We're ready.
Excellent. Ms. Hall, are you ready?
I am, Your Honor.
Then let's bring Mr. Fox out when you're ready, please.
Does Ms. Hall know that you're here? Okay. I don't know if you want me to let her in. Okay.
It's secret.
Who's there?
I'm not sure. Someone wearing a law enforcement looking polo shirt in the way back.
Judge, this is Lieutenant Dundon with Atlanta Fire and Rescue.
There we go. Oh, and there's arson in the mix. So that's why we'd have fire and rescue here.
So Mr. Fox was actually scheduled for a prelim this morning. And so Lieutenant Dundon was actually under subpoena for that. And so.
This is why Mr. Fox went to see Judge Borski first.
Yes, Judge.
What happened to the prelim?
So there was a miscommunication. ADA Turner downstairs was unaware of our global resolution. So that's why Lieutenant Dundon was downstairs. So I've been talking to Lieutenant Dundon quite a bit. And so I just let him know he could join us up here if he'd like.
Great. Okay. Well, let's get on the record. This is position 5 on our status calendar. It's Z89781. State versus Timothy Fox. Mr. Fox is here. Good morning, sir.
How are you?
I'm all right. You feeling a little better than last time I saw you?
Yeah, I've had all my medicine.
Excellent. You ready to go forward?
Yes.
Mr. Fox is here with his lawyer, Ms. Wood. We have Ms. Hall, the prosecutor, who is appearing via Zoom, although my guess is she's probably like 400 yards away, but that's all right. She's zooming in. And we are doing, I believe, 2 things today. We are handling the revocation in the Z case, and Mr. Fox is going to enter a plea in an accusation to the arson, and the state will be not pursuing the aggravated stalking charges. And if everything goes according to plan, that will be 3 resolutions, if you will.
Yes.
Is that your understanding, Ms. Wood, as to what's going to happen?
Yes, Judge.
More importantly, Mr. Fox, is that your understanding of what's going to happen? Okay. And Ms. Hall, that's your view too?
Correct, Your Honor.
Great. So I think the way we'll do it is take the plea, because the revocation will be a consequence of the plea. So we better make sure we get through the plea, and then the rest will all fall into place. If we're going to do that first, then Mr. Fox, I need to tell you that in a moment, Ms. Hall, and I'm going to do this. There, now she's big on your screen. Ms. Hall is going to put you under oath. Once you are under oath, it's important that you answer all of her questions and mine truthfully. Just as important that if you have questions of your own because you're curious about something or you don't understand what's happening or whatever the deal is, you let Ms. Wood or me know that you've got a question so we can pause and answer your question. Will you do that?
Yes.
Excellent. All right. Ms. Hall, when you're ready.
Thank you, Your Honor. Mr. Fox, can you please raise your right hand?
Oh, before we go any further, I need to make sure I've got, and we have in the record, what the case number is, and now I've got it. So we are taking a plea to 22 SC 182275. That's an accusation, and it has 2 counts of arson. All right. Sorry, Ms. Hall, you're up.
No, you're fine, Your Honor. Ms. Fox, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Can you please state your true, correct, and legal name?
Robert Marvin Fox Jr.
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
Medicine.
Did you took some medicine today?
Yes,
The judge is probably going to ask you what type of medicine that was.
he knows.
I do know, but I do know from, not because I gave it to you or because I use it, but because we've talked about it before. Mr. Fox, the medication that you did receive this morning, does it in any way make it hard for you to understand what we're talking about?
Makes it so I can understand what we're talking about.
It's helpful.
Yes,
It doesn't make you drowsy or woozy. It allows you to focus on what's going on.
yes.
Great. Okay. Ms. Hall?
Mr. Fox, how old are you and how far have you gone in school?
54.
And how far did you go in school?
I got a bachelor's degree in clinical psychology.
Okay. And are you able to read, write, and understand the English language?
Yes,
Do you understand that you've been charged with 2 counts of arson in the 1st degree?
yes,
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
yes, ma'am.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No,
Are you satisfied with her services?
yes,
Counsel, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
So waived for purposes of this hearing.
Mr. Fox, have you been arrested on these charges?
yes,
I ask because the state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
No.
Mr. Fox, has your attorney advised you of the minimum and maximum sentence to the charges that you're pleading to?
yes,
The minimum and maximum sentence for arson in the 1st degree is 1 to 20 years to serve. You understand?
yes,
And do you understand this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of 20 years to serve 5 years, balance on probation. That is for both counts in the indictment, but the court does not have to accept that recommendation. The court can sentence you to the maximum on these charges and can run those sentences consecutively or one after another. Do you understand?
yes,
Do you understand this is a guilty plea, which is permanently recorded on your criminal history?
yes,
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including the federal courts?
yes,
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
yes,
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
yes,
Do you understand that you're not allowed to possess or use a firearm while on probation?
yes,
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
yes,
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
yes,
Do you understand you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
yes,
Excuse me. Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
yes,
Do you understand that by pleading guilty, you're giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes.
In indictment number 22 SC 182275, how do you plead to the 2 counts of arson in the first degree?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you only have 30 days from today to appeal this guilty plea conviction?
Yes.
Do you understand that you only have 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Thank you, Mr. Fox. Your Honor, if this case had proceeded to trial, the state expected the evidence to show beyond a reasonable doubt that on May the 3rd, 2021, around 3:30 a.m., fire department was called out to 368 Andrew J. Harrison Place, that's Northwest Atlanta in Fulton County, to report a fire. When they got there, they did notice fire damage to the structure of a vacant 1-story dwelling. This dwelling was under construction at the time. Most of the damage was confined to the attic on this particular day, but it was classified by the fire unit as an arson. They started an investigation, but then on May the 7th, they was called back out to the same address in Fulton County. And this was around 3:20 a.m. When they arrived to the second fire. It's the same dwelling, but at this point, the dwelling has been completely burned down. During their investigation, Your Honor, a witness came forward that talked to investigators that had information that the defendant received a ride from a Carlos Crawford the night of the first incident, where Mr. Crawford took the defendant to a gas station. The defendant told that individual that he didn't want to be seen buying gas from that gas station. So Mr. Crawford bought gas, gave that gasoline to the defendant. The defendant and Mr. Crawford went back to the location where the defendant made a comment, was quoted in our report as to what was said, but it was in reference to him mentioning the house being burnt down. The quote doesn't make any sense, so I'm not even going to mention it, but it was in reference to this house burning down. That same witness went back to that location the next morning and saw that there was fire damage to that house. That's when the attic had the attic caught on fire. In further investigation, that same witness also told investigators that the defendant wore an ankle monitor. Officers were able to pull the GPS location up on the ankle monitor, and they were able to pinpoint him, the defendant being at this location, the incident location, both on May the 5th and May the 7th, specifically on May the 3rd and May the 7th. Specifically on May the 3rd, his GPS places him at that location 45 minutes before police were called. He was there for a total of 45 minutes, starting at 2:18 in the morning, and then police were called at 2:51 a.m. And on May the 7th, police were called out at 3:20. The GPS put 3:17. The GPS put the defendant being at that location at 3:10. Officers did try to speak with Mr. Fox about what had happened or if he was at this location. He refused to do an interview. So they did speak with the owner of this location. And I apologize if y'all can hear the vacuum cleaner in my background.
Told you should have come here.
You were right, Judge, as usual. They talked with the owner, and there is a relationship with the defendant knows the contractor. The house was being remodeled, and at the time, the defendant was given $3,000 by the contractors. His job in the sequence of jobs with the constructors was that his job at this house while they were doing construction was to get rid of the debris and to actually pay some of the workers via Cash App. The owner learned that he was not going to be able to obtain permits to continue to renovate this home. So at that time, he gave the defendant was given $3,000, and that's the conclusion of the job. And after that was when the defendant intentionally burned down this home. I don't know if the first attempt of trying to burn or start a fire in the attic was the intent was to burn down the entire home, but it did not spread to the entire home until the second arson happened on May the 7th. But warrants were taken out for the defendant, Your Honor. He was arrested, but he didn't give a statement as to anything that happened in this incident. But we do have his GPS on his ankle monitor to put him there. We do have a witness that took him to get the gasoline and statements that he made to that particular witness about this house being burned down. And then that witness also witnessing the house being burned down right after those statements were made by the defendant. And that is all for the state, Your Honor. I will allow probation to tell you the defendant's history.
Okay. Ms. Tucson, you're being allowed to tell us about the criminal history.
It's currently active.
I know there's the Z case. That's why we're here.
And that's it.
Okay. And how much time remains on the Z case?
The probation ends September 30th, 2056. So 34 years, 4 months, and 20 days.
That's a lot of probation. Okay. Ms. Hall, what's the thinking behind having probation in the arson cases as well? It's not going to extend Mr. Fox's time on probation. So that's not why I'm asking. I'm just curious, as opposed to just 5 years to serve, I say just, it's a lot of time, but as opposed to a sentence of 5 years to serve as a result of the two arsons, same structure, but two different events, why the 15 years probation?
Honestly, Your Honor, I didn't put any thought into it. I'm just honoring the negotiated plea between Mr. 88 Whitenhauer and the defense counsel.
You're right.
I didn't think of it, but if we're going to revoke some of the time that he has left on the probation case, I'm fine with him just doing 5 years to serve on this case and then continue him on probation on the Z case.
Okay, I'll think through it. I just was curious if there was a state perspective, and I forgot that you were very graciously parachuting in for Mr. Whitenhauer, and so the die was cast for you. It was 20 serve 5. All right, got it.
And I want to add, Your Honor, I'm sorry, we have spoken with the victim, the property owner of this case. He did tell us that he purchased the house for $120,000, and he's not going to file an insurance claim for the house being burned down. We did explain to him that our offer was the 5 years to serve and in the restraints of having restitution attached to the case. So I just wanted to put that on the record, Your Honor.
Okay. So Mr. Hamilton is the victim. It was his structure that burnt down. So he appreciates he's not going to get restitution from Mr. Fox, but for some reason, he's also not getting insurance involved.
That's correct, Your Honor.
Okay. All right. Ms. Jackson, do you have anything else for Mr. Fox?
Your Honor, if you'd like to know how many cycles he has and about how many felony convictions, I can provide the court with that if you would like it.
I would. How many, and in particular, if there are cycles after the Z conviction? I don't know if it shows up that way for you.
No, it doesn't.
Okay. How many cycles are we talking about?
11 cycles. There were 5 out of Georgia and 6 out of Florida.
Okay.
Yeah, the the last felony conviction was in 2010 out of Florida.
I never heard of it.
For a charge associated with the CWAC. And prior to that, there was one in 1997 that was associated with a CWAC as well, Your Honor.
In Florida or Georgia?
That one was in Georgia, 1997.
All right.
And there was one in 1995 out of Florida that was associated with a CWAC as well, Your Honor. Nothing in addition.
Great. Thank you for sharing that.
Yes, sir.
All right. Ms. Wood.
Thank you, Judge. Judge, Mr. Fox is 54 years old. He's originally from New Jersey. He's been here in Georgia the past 30 years or so. He is a high school grad and has a college degree, as you heard. He was flipping homes and working in that remodeling industry prior to this incident. I do want to put on the record, he served a total of 299 days at this point. So originally for the arson case, he was arrested and picked up on June 28, 2021. He served 41 days and then bonded out on August the 7th, 2021. And then he picked up the stalking case and he served from August 26th, 2021 until the present for 258 days. So add those together, it's 299. I did just want to put that on the record so that he can get credit for that time. Judge.
Both cases. Both cases.
Right, yes. And Mr. Fox would like to address the court here shortly, Judge.
Sure.
I just wanted to add that up until this point, all of the information that we were working off of was the name of an incorporation. I'm assuming maybe that's I think she said Hamilton was the name. So I just asked Mr. Fox, he's not aware of, he doesn't know that person personally. So I just wanted to put that in there, Judge.
Okay.
Mr. Fox has indicated to me that at the time of this incident, he was off of his medication. So we did just want to let the judge know that information as well. And I believe prior to this incident, he had only had one other probation violation on this case that I know of.
In June of 2020, I revoked Mr. Fox for 4 months, reduced to time served. It doesn't say why on the order of revocation. That's frustrating, but he got revoked.
Judge, I did, at some point I looked at the transcript from that because that Mr. Franklin had the case at that point.
Mm-hmm.
Part of that revocation was that Mr. Fox get his medication straightened out.
Mm-hmm.
So I just wanted to add that, and I believe Mr. Fox would like to address the court, Judge.
Okay. I'm trying to get my hands or eyes on the Z indictment, but I can't. Well, here's the final disposition. I'll just look at that. Okay. I just wanted to know what the charges were. And it was Judge Downs, which is why Mr. Fox's case is with me. Mr. Fox, you can share with me anything you want. I got a question for you first. We heard from Ms. Jackson, who is able to look into other states' criminal histories, that maybe you've had some cases in Florida. Is that accurate?
Yes.
Okay. Do you think you're on probation out of Florida, or those cases are closed out?
They were closed out when I came here.
Okay. All right. What do you want to tell me?
Just that I wasn't on my medicine and I was just having a real hard time.
Was the work you were doing at that address on Andrew Hairston Place, was that your primary project? So that when it got shut down, you had nothing else?
Well, what happened, Your Honor, was I was off my medicine and then I met this guy named Dustin Goolsby. And he gave me some work and I wasn't thinking real well. And I told him I wanted $6 an hour and just all kinds of crazy stuff. And so I was working for him. And then while I was working for him, he approached me about the fire. And when he approached me about the fire, that's where the $3,000 came and he paid me to set the fire.
Okay. Got it. you've been on your medication since you've been in custody.
Yes.
When, okay. When you get out a little ways on down the road, where will home be for you? Do you have a place or you'll be starting all over?
I'm not sure. My girlfriend's not real happy with me and it's her house I stay in.
Yeah,
So, but she hasn't sold the house.
okay. If your girlfriend is out of the picture, do you have family in Georgia? Family in Florida?
No.
Family in America?
Well, not that would want to have anything to do with me.
Okay, so you'll be on your own.
Yes.
Do you have ties to Fulton County? Would you?
Yes, my girlfriend.
Okay, but
She
if,
won't leave me. She may not let me live in her house, but she won't disappear.
okay.
She's got a lot of patience.
Okay, and she lives in Fulton County?
Yes.
Okay, so having a condition on your probation that you stay out of Fulton County would not be helpful in terms of getting you a stable situation. Because if your girlfriend was going to let you be around her, that would mean you would want to be in Fulton County.
Yes, sir.
Okay, all right. You said that your real name is Robert something Fox.
Yes.
We've got you down here as Timothy Fox. You are the same person.
Yes.
It's not your twin brother.
No.
All right. Well, I find there's a factual basis for your plea, and that your plea is knowing and voluntary. On the knowing piece, that means you've understood what we've been talking about. You've told me that you did get your medication, and your words were, because of the medication, you can understand what's going on. Any questions about anything that's been said?
No.
Voluntary means that no one is forcing you to enter this plea, and you may not be real enthusiastic about it, but it is a decision you're making upon advice of lawyers of your own free will. Is that correct?
Yes.
I'll accept your plea. I'm sentencing you pursuant to the Probation Options Management Act, which means that while you're on probation in this case, and I am going to have them overlap, it's not going to cost you anything more. You don't have to report twice because you've got two cases. I'm just a little worried about a case that starts with a Z, that the world may just forget about it. And this is a newer case. And so we're just increasing the likelihood that you remain under supervision. If while you're on probation, you have a technical violation, you and probation will sort through that. But if it is a substantive violation, you get arrested again, or there's some kind of erratic behavior because you get off your medications, that'll come back to me. I will follow the negotiated resolution, and on count one, sentence you to 20 years to serve 5 years with a balance probated. You'll get credit for all the time you've been in connection with your arson arrest. It sounds like it's two pieces. You were arrested and then you bonded out and then you went back in because of the probation warrant, but that's all connected to the arson. Count two is the same, 20 years to serve 5, balance probated. They'll run concurrently with each other. And this sentence will run concurrently with your sentence in Z89781. Because of these new convictions, 2 counts of arson, I am going to revoke your probation in Z89781 for 5 years. You'll get credit for the time you've been in, and that revocation will run concurrently with your sentence in this new case, the 22 SC case. And then you'll be reinstated on probation in the Z case. So you'll have still around 29 years worth of probation on that case. That will run longer than your probation in this case, but your probation will be running at the same time in both cases for about 15 years. You may well parole out before the 5 years are up. Parole and probation are supervised by the same team, so you'll be reporting to the Department of Community Supervision. Mr. Fox, in normal times, whatever those are, we'd be handing the indictment or accusation around for you to sign and Ms. Wood to sign. Do you authorize me to sign the accusation on your behalf indicating your guilty plea?
Yes.
Ms. Wood?
Yes, Judge.
Ms. Hall?
Yes, Your Honor.
Okay. Ms. Tucson, anything you need to tell Mr. Fox about reporting to probation or parole upon the completion of the custodial period of his sentence?
What county will you be living
Fulton,
in? In Fulton, is it the address you have in file that Andrew is?
Yes.
Is 351?
yes,
Okay, you know where probation is on 276?
yes, next to Garnett train station.
Okay, so yes, you would have to report within 48 hours,
Okay.
whenever you are released. From prison.
Okay.
Do inmates get reminded of that when they get released, or we're just hoping everyone remembers what you told them 4 years ago?
Well, they usually get a parole certificate, or it's a paper that is printed out and it lets them know, gives them the address.
Great.
And it's-
Okay. Ms. Tucson, do you need anything else in connection with the revocation?
No.
Okay,
I'll have to submit the revocation order and then.
correct. Ms. Hall, anything else for the state?
Nothing further from the state, Your Honor.
Thank you for filling in for Mr. Whitenhour. Ms. Wood, anything else for Mr. Fox?
No, Your Honor. Thank you.
All right, Lieutenant, anything from Fire and Rescue? All right, thank you for being here. That concludes our calendar.
Good luck, Mr. Fox.
Thanks, everyone.
Thank you, Judge.
Who's Bradley Crawford? Anyone know?
I have no idea.
Your Honor, I have a quick question when we come off of YouTube.
Sure, let's do that, and then people can tell